Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. Har Har Mahadev, Jai Shiv Shambhu. With the blessings of Almighty, I am going to emphasize on one of the most important topic concerning about your rights. I am emphasizing on your fundamental rights. I am emphasizing on your fundamental liberties. Just give me few minutes and listen what I am going to convey you. Leave all your work. I know that you are busy in your life. But inter alia, if you are aware about your rights, your life could be easier one. Please maintain a proper notebook along with a pen or pencil. Do you know arrest inter alia compromise your freedom? More specifically, when it is the illegal arrest. Assume the panic you are having. Assume the panic your loved one is having. Because reputation once gone, it could not be restored. An illegal arrest is one of the glaring example of the same. To prevent the individual from being the subject of illegal arrest, from time to time guidelines are propounded by Honorable Supreme Court of India. And the recent guideline among them is propounded in the case of Arnesh versus State of Bihar, wherein it is specified that arrest inter alia bring the humiliation. It curtails the freedom. And that's why there's a need of great caution. Do you think that our Indian police is serious to follow that judgment? Subsequent to this, it is observed by Indian courts that the concerned police is not serious. And even the erring officers were sentenced as well. But despite of that, they are continuing on the sad path. Do arrest to prevent the crime. But Supreme Court says no arrest is required. Do arrest only when it is required. So basically, we have to understand the provision of law. We have to understand the basis of law. Because whenever we are in a trouble, we find the lawyer's office as a hope. But I want to clarify that you are the only hope for yourself. If you could help yourself, the God is available to help you. But if you cannot, then in this entire world, no one can help you, even myself. So, on theoretical perspective, it is quite clear. Arrest should not be done in the mechanical way. It should not be done without any specific reason. If the powers are going to be exercised in the cyclostyle way and the liberty of the individual is compromised, in that scenario, the erring officers would be responsible. In addition to this, we are having specific provision under BNSS in which it is specified that if a person causes the police to do the illegal arrest of any individual and later on it is found that the arrest is illegal, the magistrate may order for the compensation. For this, you may study section 339 of BNSS. When law is helping you, then why you're getting worried? Just emphasize on the provision of law. So first thing we have to note down is that the arrest cannot be in the mechanical way, in the cyclostyle way, without any reason. So basically we are going to rest on the core question. Why to do arrest and why it is sine qua non means required. Sine qua non is basically a Latin word which means why it is required or indication of requirement. As per section 35 subclause 1 subclause B of BNSS, the police may do arrest by specifying multiple reasons, either in whole or in part. They may say that we want to do the proper investigation of the case and accused is going to hamper the process, and that's why the arrest is done. So we are not supposed to give them any way to justify their claim. It is seen that while doing the arrest, you do physical resist, you may assault, you may even use force, even you abuse the police. Do not do such practice, because if you are doing such practice, you are going to justify their process. Please keep calm and ask only one thing: where is my lawyer? And on what grounds I am going to be arrested? These are the magical words. They may say that the arrest is required to prevent the accused to commit any further offense, but such specification must be supported by specific evidences. If the specific evidence is not on the record in terms of corroboration and consistency, we may get the benefit. And apart from that, they may say that the arrest is sine qua non to prevent the accused from causing the evidence to disappear, which includes tampering as well. And they may also quote that the accused is going to induce or threat or doing the promise to any person acquit with the fact of the case, not to depose against him before court or before police. They may say that there's a possibility that the accused will flee away from course of justice, and that's why we have done the arrest. But I want to clarify that the arrest cannot be done in the mechanical way, in the cyclostyle way, even as per section 35, subclause 1, subclause B of BNSS. The police is required to specify the reasons. If there is no reason, arrest would be illegal. Now the important question arises: if the arrest is done in the illegal way, what we can do? We can challenge the arrest. But for this, we have to remember 4 important principles of law. Number 1, we have to check out whether there is any violation of section 35, subclause 1, subclause B of BNSS or not. Number 2, we have to check out whether there is any violation of section 35, subclause 3 of BNSS or not, because the said protocol correspond to section 41A of CRPC, which says that if arrest is not required, in that scenario the IO could serve a notice to the concerned accused with direction to comply with. I want to clarify that Honorable Supreme Court specified that if the offence is punishable with imprisonment up to 7 years, in that scenario the said notice is mandatory. If it is not given and arrest is done, the entire proceeding would be illegal. And that's why I could say that the police is duty bound to comply with the intent of section 41 of CRPC or section 35 subclause 3 of BNSS whenever the offence is punishable with imprisonment up to 7 years. Please be noted. And apart from that, whether the access of lawyer is given to you or not, if it is not given, then it violates section 38 of BNSS. In addition to this, the ground of arrest is required to be communicated to you in writing. If it is not done, again it is the violation. In addition to this, we are supposed to note that the concerned person so arrested or detained is required to be produced before magistrate within 24 hours from detention or arrest, whichever is earlier. If it is not done, then we could take the benefit. But now the important question arises: how to hit the said scenario in the practical way. The way in which we could be succeeded is the proper drafting, because drafting is the key to success in criminal litigation. You must know the principles which I averted you and have to specify in your petition in the specific way so that you could easily point out the violation. I want to clarify you. For example, if you want to specify the violation of Article 22 of Constitution, which says that within 24 hours you are required to be produced before the magistrate. And if it is not done, just do one thing: say to your lawyer, mention the fact of detention along with date and time. And request is required to be made to call the explanation from the concerned police. And if there is no justification, and apart from that, the detention is beyond 24 hours, in that scenario detention would be illegal, and once it is proved that detention is illegal, arrest would be illegal and you deserve the benefit of bail. So it depends upon you in which manner you are going to submit your averment. Just pinpoint your case, pinpoint the violation, pinpoint about your rights, and apart from that you have to specify the perjury cost to you. So the law is to help you, but it depends upon you in which manner we have to take the benefit of law. So in that case, the concerned court found that the officials are erring officials. They done the arrest against the mandate of judgment of Honorable Supreme Court. Verdict, that is Ernest versus State of Bihar. In addition to this, the arrest memo is basically a printed performa. Simply in the fill in the blanks, they are going to compromise with our liberty. Oh, What a great task they are doing. In that scenario, if you think that a person from universe will come and will help you, you are wrong in your approach. You must help yourself, which I told you earlier. The hearing officer was not only sentenced, but also the order of compensation was also made. The judgment is pronounced by Honorable Jharkhand High Court. Title is Irshad versus State of Jharkhand. Judgment date is 17th of December 2024. So whenever you are going to be arrested in the illegal way, you may emphasize on all these points. Could secure your liberty from being compromised, could protect your rights from being prejudiced. See you in the next video.